Welcome to the Monocle Banking Podcast, all about the trends, challenges and opportunities shaping the financial and banking sectors, not just in Africa, but here in South Africa specifically. I'm your host, Michael Avery, and today we explore one of the most crucial aspects of corporate survival in South Africa, business rescue and insolvency. And our guest is someone whose name has really become synonymous with this field, a man who's helped shape the business rescue landscape in South Africa. He's not only the director and head of the Insolvency, Business Rescue and Restructuring practice at Werksmans Attorneys, but also a globally respected figure in the world of corporate restructuring, the chairman of SARIPA, which is the industry organization representing business rescue practitioners and insolvency practitioners in South Africa. Dr Eric Levenstein has literally written the book and has been at the forefront of some of South Africa's most high-profile business rescue cases, including the likes of, well, there are too many to mention, but it's a great pleasure, Eric, to have you on the show. And in today's conversation, we're going to explore some of your career and some of the challenges and triumphs of South Africa's business rescue regime since its introduction in 2011, its insertion in the Companies Act, and perhaps most importantly, what lies ahead for the future of corporate restructuring in our country. So let's just start with your journey. What led you into the field of business rescue and insolvency? What motivated you to pursue this as a career?
So Michael, believe it or not, I grew up on the beaches of Durban. I was a little bit of a surfer. I wouldn't say ever thinking about going professional, but I went through my schooling career in Durban and did my BCom in Durban, and then ended up doing my LLB at Wits and joined Werksmans in 1987 to serve articles. Werksmans Attorneys in Johannesburg. So I've actually been at the firm for almost 38 years, which literally is a lifetime. I got involved in insolvency law literally by default in the early 90s when I started working in the field with a team here at Werksmans. All we had in those days was liquidation. So we had no business rescue at all. And all we would do is liquidate companies that were in trouble, which was really a very negative outcome and often quite a depressing outcome, which meant liquidation is the end of the company's life. Jobs come to an end and where the company would stop trading. So prior to 2011, liquidation, as we would say, was the only game in town. And then in 2011 came along business rescue. It was really a massive breath of fresh air to me. It was a game changer. Business rescue brought us into line with international jurisdictions. It gave distressed companies that really were on the verge of insolvency or financial cliff, literally teetering over the edge, giving those companies a second chance and a possible fresh start. The mechanism, in my view, when we first looked at it, was a good one and very laudable to me as an approach to distress. So I got stuck in, looked at the legislation in its draft form, made some submissions to the South African Law Commission at the time, and then we got our new 2008 Companies Act, and I was literally hooked, I suppose. I spent hours poring over the legislation, looking at how it all fitted together, and just generally since then I became fascinated by the whole idea and concept of rescuing companies in trouble and with the positive outcomes that would flow from it.
Absolutely. And I mean, if one just takes a step back and you think about how difficult it is to start and sustain a business, what are the stats? Within 2 years, I think 90% of new ventures fail. So we really should be doing everything we can to ensure that businesses that have history, that have a brand equity in the market, that maybe have made some poor financial decisions, have taken their eyes off the cash flow of the business, for example, but still have something to save, that we try and save them, especially in a country with the levels of unemployment that we have and needing to ensure that we sustain economic growth. But I want to come back to your career path. Very interesting, from surfing into how we help companies surf the waves of volatility in the market. But you've also got an extensive academic background, including a doctorate in business rescue. How has your academic work influenced your practical approach to business rescue?
Well, it's interesting. I did a doctorate by invitation at the age of, I think it was close to 56, 57, which is pretty late to start doing a doctorate, particularly with my busy practice. And I do run a big team here at Werksmans with lots of lawyers working in this field of law. So in 2012, shortly after the legislation came onto our statute books, the University of Pretoria invited me to do my doctorate. So off I went. It took me 4 years, very hard years. I spent most of my time on Saturday mornings dealing with my doctorate. It was one of the first ones on business rescue, and eventually it came together, and I got the doctorate. And I must say, the one thing I remember very well is my graduation in February 2016 with my two sons looking at their father as a student graduating, which was quite something. Anyway, it's really influenced the way I've practiced over many, many years. And what was really nice is my thesis was converted in 2017 by LexisNexis into a book. And the book remains the only standalone book on business rescue in South Africa. It's a loose leaf. It's updated every year with the latest cases. It has become a go-to academic book, I suppose, on business rescue, and where a lot of my extracts are often quoted in judgments, which I must say gives me a real kick when I read a judgment and they're quoting some of the things I've said. But it does keep me on my toes. I've got to update that every year. And it certainly is something which has influenced, let's say, workflow, incoming referrals, outgoing work that I produce. So it has stood me in good stead, Michael, over a lengthy period of time.
Eric, what I find really inspirational about that is not only the fact that you did it while running a practice. I mean, I actually don't know how you find the time to do that, given how busy lawyers are and the hours that you work. It's almost incomprehensible. But the fact that, later on in your career you did, and I think so often later in our careers, we do become a little bit stuck. Often we kind of in our comfort zones and we don't row the boat out that far. And it also shows you, when I said you wrote the book, I mean, you've literally written the book on business rescue in South Africa. So, and you've seen the evolution. It has come in for some criticism. It's been over a decade since business rescue was introduced under Chapter 6 of the Companies Act. How would you assess the success or otherwise of the regime so far? And is the framework for business rescue fit for purpose, or are there areas that really need reform?
So, Michael, when you look at what we had before 2011 was liquidation. And remember, liquidation is a liquidator gets appointed. He comes in, realizes assets at best, and gives creditors something in the rand better than, let's say, zero. And then comes along rescue, which is a system that brings South Africa into line with what we see in international jurisdictions. So when you look at the USA, they've got Chapter 11. In the UK, they have voluntary administration. You have similar regimes in Canada and in Australia. But at the end of the day, it's always a better option to look at a rescue as an option to see whether or not the practitioner can come along, supervise a process, engage with your stakeholders, and in particular with your creditors. Obviously, you would be financially distressed if you're filing for business rescue, and to try and put together a plan which ultimately rescues the company, or let's say restructures the company. Now, it's not for everybody, and not every company should go into a business rescue process. Often companies should in fact be filing for liquidation. But over the last decade, we've seen some really interesting and high profile business rescue matters. I always remember, Michael, my very first rescue was the Pearl Valley Golf Estate. Down in the Western Cape. And then we did, all sorts of very interesting matters, Stutterfords, Melt Stores, if you recall, Edcon, SAA. There were a lot of airlines that went into rescue, one time Nationwide, Mango, and more recently Comair. And it really is industry agnostic. It cuts across every single sector of our economy. We've done rescue matters in the horse racing industry, Pumalela, aeronautical engineering, and mining and construction. So it really is something which I think corporate South Africa has bought into. Some have been more successful than others, probably the most notable being Edcon, where Edgar's, in fact, was sold to Retailability and Jet Stores was sold to TFG. And those companies are trading really, really well with the outcomes from a rescue. SA is flying. Yes, they have their own issues, but it's still flying. It came out of a rescue. And so when you look at the success of business rescue, it's part and parcel of how you have to turn around companies, where you have to give sometimes a company a fresh start and ability to compromise debt, maybe restructure your management, your board, and of course restructure prejudicial contracts, which is all part and parcel of a business rescue plan. So in my view, it has been successful. I mean, Stats South Africa today just pushed out some liquidation stats, since between January and August of this year, you've had over 1,000 companies filing for liquidation. Now, many of those companies could have potentially been rescued, maybe if the board was properly advised or if they engaged early enough in the distress cycle to take a good hard look at a business rescue. So it's about educating directors, educating corporate South Africa, getting the buy-in from the banks to support the process. And in years to come, I think it will continue to be a tool for the restructuring of distressed businesses and companies.
Yeah, and I mean, you've mentioned some really high-profile success stories. I think Edcon, if you look at that story, the biggest private equity buyout at the time, and sadly, often, what happens to a business is it falls on hard times because there isn't requisite focus on the balance sheet, there's too much debt, and the CFO or the financial director maybe are pursuing the next big sponsored project by the CEO, maybe some M&A activity, and they take their eyes off the ball, and that is the basics of cash flow sometimes. And so, if there is still enough in that business to salvage, why let the business hit the wall? Rather try and restructure things so that all parties maybe get a little bit more out at the end of the day. If you go into a liquidation, you might get 15 cents as a bank out the rand versus turning things around, taking a bit of a haircut initially, but then actually getting more out as the lender to that business over the long term. That said, though, I mean, if you look at it, banks and financial institutions have historically, I think, been wary of business rescue. How would you describe their current attitude towards the process?
Well, Michael, we had a business rescue summit at the Houghton Hotel earlier in the week. And in fact, you were there. And we had some really interesting, frank and open discussions with the financial institutions, with the business rescue practitioners. For me, I really believe that the banks have bought into the process. Yes, they won't always back a business rescue. They might say, well, liquidation for us as the bankers or the financiers, in our view, is the better option. But at the end of the day, I think the banks understand how important it is to sustain companies in our marketplace, and particularly when it comes to the preservation of jobs and employee positions in corporate South Africa. So yes, they might be wary. Sometimes to a large degree, they're skeptical about the process. But at the end of the day, I think banks recognize the fact that business rescue remains a developing field. Obviously, there's room for improvements in the legislation, improvements in the skill sets of BRPs. I think the banks recognize that they have a role to play in educating directors so that they can file for business rescue far earlier than they currently do. But at the end of the day, I think the banking fraternity is looking at trust factors within the process. How transparent is the process, and what are the levels of communication between boards of directors that are facing financial distress and where they don't bring, let's say, the banks into the tent. And I think that's the most important thing, is that directors need to understand the optionality, keeping your bankers and your lenders close, and obviously inviting the right business rescue practitioner to come in, do an assessment, and see whether or not the company is in fact a candidate for business rescue or alternatively a candidate for liquidation. We recently at Werksmans published a joint guidance note with the Institute of Directors where we look at business rescue, financially distressed companies, warning signs, and how directors should understand the business rescue process. And we're quite excited about the publication because it really does get in, firstly, to the Institute of Directors and certainly into corporate South Africa to try and educate directors far better as to the option of rescue and understand the process better. And again, as I said earlier, get into the business rescue turnaround phase at a far earlier position on the distressed curve.
Yeah, I think that's an important point that again was raised, at the Saripa summit, where you had the bankers, you had the DFIs, you had the business rescue practitioners in the room, you had the World Bank sharing best practices. The earlier the board of directors can make that decision, can, stomach their pride, very often it is ego, and say, right, we actually need external help, the more likely the success, because, there's more potentially to salvage out of the process. But, from the banker's perspective, there's also different types of debt. There's subordinate, there's mezz, there's, and where they rank and how it's structured will also influence that decision on whether or not to go with the process. And I think that, for me, was a big takeout, is, to bring all of the parties around the table to hear the other side's perspective. And so with that process, better understanding how we can work together to ensure that business rescue is implemented more in the future to ensure we save more companies. But there are issues around how money flows upwards and downwards in a company. I think Danny Andropoulos mentioned that given the restrictions that are placed on lending during a business rescue process. So there is still some discord between the Act and pieces of subordinate legislation, isn't there?
I think business rescue fits into the Companies Act pretty well. A lot of debate happened at the time Business Rescue became part of our legislative framework, is why should it not be in the Insolvency Act, which would have been the wrong approach, particularly the fact that Business Rescue is not in insolvency at all. It's an opportunity to rescue the company. And I think really when it comes to lending and looking at Basel and other constraints on bankers, in South Africa, I think one of the bankers mentioned they understand and appreciate the social connotations to rescuing companies, obviously talking to job preservation and the like. But I think credit committees at banks, as one of the bankers said, like to play nice, because at the end of the day, it's their customers that get into trouble. And if the banks partner with the board and sit together and discuss the issues of covenants not being met, why are they not being met, what does the market look like, and hold the hand to the degree of directors and point them in the right direction to get the right advice at the right time, I think you're going to see more companies being rescued, again, at a much earlier stage in the distress curve.
Yeah.
And where ultimately you'll see some more and more success. And it's about, Michael, upping the confidence levels, both in the banking sector and obviously creditors generally, trade credit, in backing the process, where they understand that if the company fails, well, then they don't have anyone to supply their goods to. So for suppliers themselves, the preservation of companies is very, very important. And again, it's about educating corporate South Africa.
I recall, I can't remember who said it, but one of the big issues is when you go to the credit committee, there's such a negative perception of the process because it's largely due to companies in body bags that shouldn't have been in business rescue in the first place. So it comes back to understanding, when it's appropriate to actually go the business rescue route, and to ensure that you're not just using it to shield you from creditors and that kind of thing. There's also legal complexity, and the point was raised, I think the World Bank, Antonio Menezes, mentioned the fact that global best practice points to the fact that we need specialized courts, because often you're talking about specialized commercial cases here, and we know our courts are under immense strain. The court roll is it's bursting at the seams. Cases like the Westcol and Kariba rulings have been criticized when it comes to business rescue. What impact have these legal precedents had on the process, particularly in terms of post-commencement finance and creditor voting rights?
Michael, your first part of your observation on courts and whether we should have specialized courts is interesting. The legislation provides the opportunity for the minister to, in fact, put together special courts for business rescue and insolvency matters, and we've not seen that happen. So yes, we've seen a lot of judgments, over the last decade. I would say a couple of 100 judgments on business rescue, and a lot of those are dealt with in my book. But what's interesting is that, yes, we've had some decisions which have been criticized, but at the end of the day, most of the judgments have been robust. They have given clarity on aspects of the legislation, and which makes it easier for all stakeholders to understand where business rescue fits into the scheme of restructuring. Now, of course, very early on, the Kariba ruling came out, and where that jettisoned to a large degree the opportunity to have binding offers in place where a creditor who doesn't want to go along can be forced to sell its claim to a third party who does want the business rescue to go ahead. But unfortunately, the Kariba case on its facts basically determined, or the judge there determined, that you have to have a position where whoever's selling has to have a willing buyer and a willing seller in relation to a claim, and it just doesn't work. So on those facts, no one has actually gone back to the binding offer process, which is very disappointing for practitioners like myself and my colleagues. But there are other ways to determine situations where a party votes down a plan, and that's the inappropriate vote. So there's lots of developing precedent that we are seeing in the courts. The one that does come to mind, as you mentioned, is the Westcol matter, and where anyone who comes along and provides loan finance to a company in business rescue would be termed a post-commencement financier. So there is a credit line put up to the business rescue practitioner which allows the restructuring to happen, and which in fact allows the company to continue to trade while it's going through its restructuring. And anyone that puts up post-commencement finance would have a preferent position in the business rescue. Now, Westcol unfortunately determined that those PCF financiers do not have the vote on a business rescue plan, which is extremely concerning for those post-commencement financiers who do want to put up money, maybe because they want to buy the company or make an offer to the business rescue practitioner. And what is concerning, and it is pending now before the Supreme Court of Appeal, and we're waiting for that judgment, but if it goes the way of the lower court, that PCF funders do not have a vote, that might water down or dilute the appetite
Yeah.
for business rescue and having an opportunity to get post-commencement finance into the system. So again, at least our courts are dealing with the matters. We're hoping we have an opposite ruling from the SCA, and where PCF funders, in fact, do have a vote on a plan. So it is developing, and our courts are playing a role, whether we have a specialized court or not.
Well, it's encouraging to hear that the SCA is still to rule on that, because the last thing you want to do is discourage PCF providers from getting involved. We need to encourage more capital to be able to flow into this process if it is to succeed. And you did mention the appetite for family offices that maybe have specific distressed buyout funds to come into this space. And you don't want to see rulings that effectively place that in jeopardy. I want to come back to the other issue you raised about the timing of rescue. And it is one of the recurring themes in that companies enter business rescue too late. You did mention that SIPSI actually has some role and some power to play here, but probably has been a little bit asleep at the wheel. Talk to me about how we can encourage directors to act earlier and what role SIPSI has to play here.
So SIPSI is the governing body or regulator that basically looks after companies and certainly has a major role to play in business rescue. And at the moment, we see SIPSI as more an administrator than a regulator. And as one of the BRPs mentioned in his participation on the session that we had earlier in the week, they'd like to see SIPSI having more teeth. In other words, dealing with companies that are not paying their creditors, trying to encourage directors to file for rescue at a far earlier stage, and where there's something left to rescue. Of course, if you file for rescue way down the financial distress curve, there's not going to be much left to actually put into your plan. But what's interesting is one of the sections in the Act, Section 22.3, talks about SIPSI being able to say to a company, look, you're not paying your creditors. Why are you not paying your creditors? Issue a compliance notice to that company. And if they don't come to the party in respect of paying creditors, in fact, SIPSI can close them down. Now, I've discussed that with the regulator, and we've not seen any traction at this point. But I think really what we're saying is that SIPSI needs to buy in a little bit more to the BR process and being more, let's say, regulatory in trying to determine where directors make the hard decision to put companies into rescue. And I think if some of these directors are held to be liable for reckless trading, not considering the option of business rescue early enough, then we're going to see more directors filing for rescue far earlier. So yeah. I think they have a role to play going forward.
But that is the thing, while it may, illegally may say that you can be liable for trading recklessly if you're found not to have considered this given the financial circumstances you were facing. We haven't seen much enforcement of that. So it's not really a question of changing the law. It's really just ensuring that the regulator, the Companies Intellectual Property Commission, uses the teeth that it has been embodied with through legislation. We've got the government of national unity and the spirit of renewal. If you had an opportunity to speak to the Minister of Trade and Industry and Competition, what changes would you advocate for to improve the business rescue process in South Africa?
On my list, there'd be three. One is, as we've just said, Michael, is to get SIPSI to become more involved and to act as a regulator rather than an administrator. The second is to look at some of the amendments that have been put forward to the Department of Trade and Industry, which we have not seen land at all. In fact, there was an amendment put forward quite recently, but only dealing with the rights of landlords in respect of recovering certain debts that they might have to outlay in a situation where one of their lessees goes into business rescue. So there's a long list of amendments that we would like to see. For example, tariffs. We think they are no longer market related for business rescue practitioners. We'd like to see those being dealt with, and other aspects like, for example, PCF providers being able to vote. And then the third, of course, is to encourage, let's say, players in the business rescue space to, in fact, go after directors who kick the can down the road, don't make the hard decisions, leave it too late, and where the creditors are left high and dry in a liquidation scenario. So as you said earlier, we would like to see more prosecutions of directors that are, let's say, acting fraudulently, and we'd like to see that happen, obviously, from an NPA perspective. And then maybe even tax incentives for those post-commencement financiers who are bold enough to put money up into a distressed situation, and we're assuming that the company is rescued, there must be a tax incentive for those parties that want to get involved in rescuing corporate South Africa. And those would be the kind of things I would like to say to maybe the Minister of Finance and the Minister of Trade and Industry. We are meeting with SIPSI, and we're arranging that in the next few weeks. And we certainly are going to engage with, we are hoping, the Deputy Judge President, certainly in Johannesburg, to try and talk more seriously about a specialized court. So there are a lot of things happening at the moment, a lot driven by SARIPA, and certainly trying to make the changes going forward.
Very encouraging to hear all of that work going on behind the scenes. Just lastly, Eric, really has been a real treat having you on the podcast. Given your extensive career, what would you say is the most rewarding aspect of working in business rescue, and what advice would you offer to someone entering to this field today? Because that was another element that was raised, the fact that we need competent, capable business rescue practitioners, but it's a very specialized niche. You have to have someone who's either run a business and understands the law and is really competent in dealing with so many areas of finance and suppliers and law and M&A and all of these things coming together. What advice would you offer to someone entering the field today?
Well, there's two levels. Obviously, lawyers that are entering the field as advisors to business rescue practitioners, to banks, to companies in distress, like myself. And then, of course, the business rescue practitioners themselves. Two things there, Michael. SARIPA runs a really, really good course on business rescue. In fact, backed by Insol International. It's run every year. We're going into our third year next year. The lecturers are all very high-end, very practical input that's given by very experienced practitioners, lawyers as well. And that's a course that I would encourage any young person entering this field of practice to seriously consider. Obviously, getting involved in organizations like SARIPA, getting involved with Insol International. But I think one of the academics, in fact, mentioned the fact that most business rescue practitioners are very quick to delegate skill sets out to third parties, whereas maybe they should be taking the financial aspects on board, working through, let's say, cash flows and projections, and trying to upskill themselves through their own mandate. So firstly, I think business rescue from a personal perspective is highly dynamic, incredibly interesting, very commercial, and very rewarding. I mean, at the end of the day, you rescue a company, you're putting the company back into the economy, and you're preserving jobs. I mean, it's not every day that you can operate in that kind of environment. So it really is something which I find very, very exciting, and continue to find it exciting, even though I've been going in this now for almost 3 decades. And then obviously youngsters entering the field. We've got a group at SARIPA, we call them the young bloods, under 40s. We've got over 200 of them, Michael, and these are all young people getting involved in business rescue, seeing it as a career path. And I think going forward for future generations to come, business rescue will remain the iconic tool for rescuing companies in South Africa. And it's certainly kept my interest, as I said, for the last 13 years.
Well, that brings us to the end of a fascinating conversation with Dr. Eric Levenstein. I think it's safe to say that business rescue is a powerful tool in South Africa's corporate landscape. It does face some hurdles, whether it's the timing of the interventions, some of the perceptions from stakeholders, or the evolving role of post-commencement finance. But I think, Eric, as you made clear today, there are opportunities to refine and improve the process through better regulatory oversight, so more proactive early interventions, and stronger collaboration between the banks and rescue practitioners. And ultimately, what could be more rewarding than, as you say, ensuring that you rescue a company from the brink, that you put it back onto an even keel, and that you contribute in a positive way to South Africa's economy. Eric, great pleasure sharing your insights on the podcast. Thanks so much for the time.
Only a pleasure. Thank you, Michael.
Well, that's all we have for this episode of the Monocle Banking Podcast. To our listeners, I hope you found today's discussion both informative and really thought-provoking. I certainly did. And remember, make sure to subscribe and share the Monocle Banking Podcast. As always, if you've got any questions or topics you'd like us to cover, feel free to reach out. Until next time, I'm Michael Avery, and this has been the Monocle Banking Podcast. Stay informed and keep thinking critically about the future of finance.